At 4:13 p.m. on November 6, 2025, the United States Supreme Court handed the Trump administration one of its most consequential legal victories of the year. In a ruling that split 6-3 along ideological lines, the court's conservative majority allowed the federal government to fully enforce its new passport policy, one that restricts all U.S. passports to reflect only male or female sex designations based strictly on the biological sex assigned at birth. The X gender marker, which had been available to American passport holders since 2021, was effectively eliminated nationwide. The unsigned majority opinion stated that displaying a passport holder's sex at birth raises no equal protection concerns, drawing a direct parallel to listing a citizen's country of birth, describing both as nothing more than statements of historical fact. The three liberal justices, Sotomayor, Kagan, and Jackson, dissented forcefully, arguing the ruling would cause immediate and tangible harm to thousands of Americans before their legal challenges had even been fully resolved. Here is what led to this Supreme Court ruling, because the timeline stretches back to the very first hours of Donald Trump's return to power, and it reveals a deliberate and accelerating effort to reshape how the federal government recognizes identity. On January 20th, 2025, his first day back in the Oval Office, President Trump signed Executive Order 14168, formally titled Defending Women from Gender Ideology Extremism and Restoring Biological Truth to the Federal Government. The order declared that the official policy of the United States is to recognize only two sexes, male and female, defined as fixed at the moment of conception. It directed the Secretary of State to ensure that all new government-issued identity documents, including passports, visas, and global entry cards, reflect the holder's biological sex. Within 48 hours of that order being signed, the State Department had already moved to implement it. Processing of passport applications from transgender, non-binary, and intersex individuals was halted. The X gender marker was removed as an option on all new applications. Individuals who had submitted applications in the days before the order, or even on the same day, began receiving responses indicating that their passports would be issued only with the sex marker matching their birth records. For context, this reversed more than 3 decades of policy. Since 1992, the federal government had allowed citizens to request a passport reflecting a gender identity different from the sex listed on their birth certificate, provided they submitted supporting medical documentation. In 2021, the Biden administration went further, eliminating the documentation requirement entirely and adding the X marker as a third option for non-binary and intersex applicants. Trump's executive order reversed both of those changes in a single stroke. The impact was felt almost instantly. An estimated 1.3 million adults in the United States identify as transgender or gender nonconforming, and as many as 5 million Americans may be intersex. For many of them, a passport is not just a travel document. It is one of the primary forms of official identification used in everyday life, from opening bank accounts to starting new jobs to renting cars. Those affected described the policy as forcing them to be outed every time they presented their passports, heightening fear and distress and creating unpredictable safety challenges during travel and even in routine daily life. NPR. One early example came from a man named Louis, who submitted his passport application for a new document with a male sex marker just hours after Trump's inauguration, not realizing the executive order had already been signed that same day. His application was returned, and he was told only a female marker would be issued, matching his birth records. His experience was repeated across the country as thousands of individuals found themselves caught between legal identities they had spent years establishing and a new federal policy that refused to recognize them. The response from civil liberties organizations was swift. In February 2025, the American Civil Liberties Union filed Orr versus Trump in the federal district court for the District of Massachusetts, representing 7 named plaintiffs, transgender, non-binary, and intersex Americans, who had been denied passports reflecting their gender identity and seeking to represent a nationwide class of similarly affected individuals. The named plaintiff was Ashton Orr, a transgender man from West Virginia. Orr had applied for a passport with a male sex marker in January and was told by the State Department that only a female marker would be issued. His situation illustrated a broader and dangerous problem. Orr had previously been falsely accused of using a fake passport by airport security when traveling with a passport that had a female sex marker, NPR. Under Trump's new policy, he was being forced back into exactly the kind of document that had already created that dangerous situation for him. The lawsuit argued that the new passport policy violated the plaintiffs' rights to equal protection under the Constitution's Fifth Amendment, their rights to international travel and informational privacy, and the Administrative Procedure Act, the federal law governing how agencies can implement policy changes. A separate lawsuit was filed in April 2025 by Lambda Legal in the U.S. District Court for the District of Maryland, representing 7 additional transgender citizens, including a Foreign Service officer stationed abroad, students, artists, attorneys, and caregivers, all of whom had received passports showing their sex assigned at birth despite submitting proper documentation. In April 2025, U.S. District Judge Julia Kobik, a Biden appointee in Massachusetts, issued a preliminary injunction blocking the administration from enforcing the passport policy. Her ruling found that the State Department had failed to offer a reasoned explanation for the policy change and concluded that Trump's executive order was motivated by animus toward transgender people and discriminated on the basis of sex. She found that the plaintiffs had presented evidence of genuine dangers, including elevated risks of harassment, violence, and problems with airport security, particularly when traveling to countries that criminalize transgender expression. In June 2025, Kobik expanded her injunction to cover a certified nationwide class. The U.S. Court of Appeals for the First Circuit unanimously declined to lift the injunction. The administration had been blocked at every level. Blocked below, U.S. Solicitor General D. John Sauer filed an emergency application with the Supreme Court on September 19, 2025. The administration argued the lower court's injunction had no basis in law or logic, that it compelled the government to communicate information to foreign governments that contradicted the president's foreign policy directives, and that the administration was likely to succeed on the merits. Orr's attorneys fired back, arguing in their briefs that the challenge policy undermines the very purpose of passports as identity documents, and that it is aimed at the rejection of the identity of an entire group of Americans who have always existed. NPR. At 3:33 p.m. on November 6, 2025, the Supreme Court issued its ruling. The conservative majority granted the administration's emergency stay in a 6-3 decision, allowing the passport policy to go into immediate effect while lower court litigation continues. The majority's unsigned opinion stated that the administration was likely to succeed on the merits, and that the district court had overstepped by issuing broad class-wide relief that blocked enforcement of an executive branch policy carrying foreign affairs implications. Justice Ketanji Brown Jackson, writing in dissent, joined by Justices Sotomayor and Kagan, argued that without relief, transgender Americans are forced to make a difficult choice that no other Americans face: use gender-incongruent passports and risk harassment and bodily invasions, or avoid all activities that may require a passport, including travel, opening bank accounts, renting cars, and starting new jobs. She called the harm to these individuals palpable. CBS News Attorney General Pam Bondi celebrated the decision publicly, announcing it as the administration's 24th victory at the Supreme Court's emergency docket. The White House called it a victory for common sense. The ACLU called it a heartbreaking setback for the freedom of all people to live as themselves. With the Supreme Court's stay in place, the State Department is now issuing passports that reflect only the holder's biological sex at birth. Anyone submitting a passport application requesting an X marker or a sex marker differing from their birth records will face delays and may receive a passport marked with a designation they did not request. The X marker is no longer available on any new application. Individuals who currently hold valid passports with an X marker or with a sex designation matching their gender identity are not immediately required to surrender those documents. As long as those passports remain valid, they can continue to be used for travel. However, upon renewal, holders will receive documents reflecting their sex at birth. For many affected Americans, that renewal deadline is the moment the choice disappears entirely. The ruling has drawn sharp and divided reactions. Supporters of the administration's policy argue that passports are government attestations of fact, not personal identity statements, and that the government has a legitimate interest in standardizing official documents issued to foreign governments. Critics point to the direct and measurable harm the policy causes. A survey of 84,000 transgender adults found that 22% reported harassment, assault, or denial of services when their identification did not match their gender expression. Human Rights Watch. For those individuals, a passport that outs them as transgender every time it is presented is not a neutral document. It is a potential trigger for discrimination and violence. International human rights organizations have also weighed in, noting that the United States policy now puts it at odds with an emerging global consensus on the rights of transgender and intersex people. This is not over. The Supreme Court's ruling is not a final decision on the merits. It is an interim order allowing enforcement while litigation proceeds. Here is what to watch. Does the district court in Massachusetts ultimately rule the policy unconstitutional on the full merits? Judge Kobik has already signaled she believes the policy discriminates on the basis of sex. A full merits ruling in the plaintiff's favor would force another Supreme Court appeal. Does the Lambda legal case in Maryland produce a different outcome? With a separate judge and separate plaintiffs, the Maryland litigation could develop along a different track entirely. Does Congress act? Lawmakers on both sides have signaled interest. Any legislation codifying either the restriction or the right to choose could change the legal landscape overnight. Do documented incidents of harm accumulate in the public record? Real-world cases of harassment or travel disruption tied directly to the new policy could shift how courts weigh the harm analysis going forward. And does the Supreme Court ultimately take the case on full merits, issuing a final ruling that settles the constitutional question permanently? Here are three scenarios for where this ends. In the first scenario, the policy is upheld at every level. The Supreme Court's emergency ruling signals the direction it is likely to take on a full hearing. If the conservative majority rules in the administration's favor, the policy becomes permanent, and transgender, non-binary, and intersex Americans will have no pathway to a passport that reflects who they are. In the second scenario, the policy is struck down on the merits. If lower courts rule it unconstitutional and the Supreme Court ultimately agrees, the X marker and self-attestation options would be restored, and the legal precedent would limit the executive branch's ability to restrict gender marker options through executive order alone. In the third scenario, Congress steps in. Prolonged legal uncertainty could push lawmakers toward legislation, either permanently codifying the restriction or establishing a statutory right to identity documentation. This outcome is considered least likely given current political dynamics, but it cannot be ruled out. What is certain right now? On January 20th, 2025, President Trump signed the order. Within 48 hours, the State Department implemented it. Federal courts blocked it twice. The administration appealed twice. On November 6, 2025, the Supreme Court cleared the way for full enforcement. As of today, every new U.S. passport being issued reflects biological sex at birth. The X marker is gone. The legal fight is not over. The final ruling has not yet come. But the signal sent by the Supreme Court's conservative majority is clear, and for millions of Americans, the consequences are already real.